Alicia Daniel Hall, Florida probate, estate planning attorney, and realtor. If this is your first time visiting my channel, please don't forget to like and subscribe so that you will be notified as soon as I upload new videos about probate. In this video, we're going to talk about letters of administration and why you need a court case in order to get these letters. As a Florida probate attorney, one of the questions that I get from time to time is, why do I need a probate court case if all I need are these letters? It is not possible to obtain letters of administration in the state of Florida without opening a probate case. Letters of administration are actually court orders issued by a probate judge in a formal administration case here in Florida. Letters of administration provide authority to the personal representative to begin the process of administering the estate, which can include communicating with financial institutions that the decedent or the person who's passed away may have had relationships with or accounts with. So what is the process of obtaining letters of administration here in Florida? First and foremost, the process depends on whether the person passed away with or without a will. If they passed away with a will, then the will should name someone who is going to be serving as the personal representative. And so long as that person is still alive and able to serve as the personal representative, we are going to be asking the judge to do two things. One, we want the judge to admit that will to probate. That's step one. And step two, we ask the judge to appoint this person as the personal representative. If someone passes away without a will, they do not have what is referred to as a nominated personal representative. They haven't chosen their personal representative. In that instance, then someone would have to petition the court and ask for the authority to be named as the personal representative. And they're also going to have to submit an affidavit of heirs, which is basically a family tree. Florida statutes do outline an order of preference in appointing personal representatives. The statute is 733.301, and the order of preference is actually separated. There are two sections. One section deals with the order if you die with a will, that's testate. The other section deals with the order of preference if you die without a will, that is intestate. So I'm going to review the statute really quickly, and we're going to start with the testate estate. First and foremost, the number one preference in the order of preference if you die with a will is who was listed in the will as the nominated personal representative. When you create a will, you do pick the person who is going to serve as your personal representative, and that person gets priority in the preference of your estate's personal representative. If for some reason the nominated personal representative is unwilling or unable to serve in that capacity, then the second level in the order of preference is going to be a majority of the individuals who have an interest in that estate. And then the third person is going to be a devisee. So a devisee is a person who is named as a beneficiary in the will. So those are your three levels, and that is the actual order of preference if you are dealing with an estate where the individual who passed away actually had a will. Next, we're going to talk about what happens as far as the order of preference when someone passes away without a will or intestate. First is going to be the surviving spouse, if there is a surviving spouse. Second is, again, similar to with the testate, it's going to be a majority of the individuals who have an interest in that estate. And then third is going to be the next closest heir. So we're going to look at the order of relationship. And if there are multiple people who are at the same level, so maybe if we are dealing with siblings and there are 4 siblings, in that case, the court is going to select one of the 4 siblings. If all siblings are fighting and they can't reach an agreement on who is going to be the personal representative, and there's no majority because everyone basically wants to be the PR in that instance, then the court's just going to pick one of the 4. The statute also includes a provision that deals with guardians. So if there is a ward, so someone who has had a guardian appointed on their behalf, and that ward would have been able to serve as personal representative because of where they land in the order of preference, in that instance, then the guardian would actually also be able to be appointed, and they would fall in line in the order of preference as if they were the ward. So they basically would be allowed to step into the shoes in the order of preference of the ward who they are in charge of. Number one, it can't be someone who works for or holds public office under the court. And number two, it cannot be someone who works for, is employed by, or works under the judge, the probate judge that has jurisdiction over the matter. The person who is asking the court to appoint them as personal representative has to file an oath. In the oath, there are certain statements that they have to make in order to show that they are eligible to serve as a personal representative in accordance with Florida statutes. First and foremost, to be a personal representative, you must be over the age of 18 years old. You must affirm that you have never been convicted of a felony. As of November of 2021, the Florida statutes were updated to add a new eligibility requirement. And that one states, I have not been convicted in any state or foreign jurisdiction of abuse, neglect, or exploitation of an elderly or disabled adult, as those terms are defined, and then it provides another statute that defines those items. The fourth statement that a person who is petitioning the court to appoint them as personal representative of an estate must make is that they are mentally and physically able to perform the duties of a personal representative. And finally, they must either be a resident of the state of Florida, or if they are not a resident of the state of Florida, then they have to meet one of the following criteria. Number one is they're either a legally adopted child or parent of the person who's passed away. Number two is they're related by lineal consanguinity, which means they are a descendant, so the children of or even the parents of the person who has passed away, or a spouse, a brother, aunt, niece, nephew, or someone related by lineal consanguinity to one of those people that I just identified. And the third option for someone who is not a resident of the state of Florida to qualify as the personal representative is they are the spouse of a person who is otherwise qualified under one of the provisions above. In the oath, the person must also state that they will faithfully administer the estate in accordance with Florida law. The judge may or may not require the personal representative to post bond before they're going to issue the letters. So the way this looks is the judge will enter an order appointing so-and-so as personal representative. And in the order, the judge will say, this person has to post a bond in the amount of X. They'll actually put a dollar amount in there. And at that point, the personal representative will need to reach out to a bonding and surety company in order to obtain that bond. Once the bond has been issued, the attorney will submit proof of the bond to the court and ask the judge to now please issue the letters of administration. So, depending on whether there is a bond requirement or not, there are going to be either 3 or 4 steps involved with the letters of administration. The first step is going to be the petition for administration. Number 2 is going to be the oath. Those two are done regardless of whether there's going to be a bond. The judge is going to issue an order appointing so-and-so as personal representative. And if there is a bond requirement, you're going to have to submit the bond. And then finally, you have the letters of administration that are issued by the court. If you have recently lost a loved one who was a resident of or owned property in the state of Florida and need assistance with the probate, please click on the link below to schedule your free probate consultation.